Good morning, everyone. Thank you for joining us today on the 10th of December for our webinar on European Succession and Brexit, a guide for beginners. My name is Emma Seaton and I am a solicitor in the international and cross-border estates team at Stone King. I'm joined by my colleague Dan Harris, who is head of the team and a partner of the firm. As webinar attendees, your computer cameras and microphones are turned off. You will be able to communicate with us to ask your questions at any point during the webinar via the Q&A function. This option is available on the right-hand side of your screen, and it looks like a square box inside a circle. You can type your question and it will be sent directly to us. All questions will remain anonymous, and we will be addressing as many questions as possible at the end of the webinar. If we run out of time today, we will follow up on any unanswered questions after the webinar. And finally, in the next few days, you will receive a copy of today's presentation and a link to the webinar recording, so you can watch it again or share it with your colleagues if you wish to. So we will be discussing the following topics today: succession, Brussels 4, otherwise known as the European Succession Regulation, inheritance tax, and double taxation treaties. We will discuss these topics as they apply to our clients at the moment and also after Brexit. Succession. Who will inherit your assets when you die? Under English law, you are free to leave your assets to whoever you like. Theoretically, you can disinherit your family and leave your fortune to a charity if that is what you would like to do. However, I've starred this point because the freedom to leave your entire estate to whoever you like is in reality slightly limited. For example, you may own property as joint tenants, or a proprietary estoppel claim may be made against your estate, or indeed a claim under the Inheritance Provision for Family and Dependents Act 1975. This is in contrast to civil law jurisdictions, like many jurisdictions in Europe, where it is likely that there are strict rules in place as to who you can leave your assets to on your death. This is known as a forced heirship regime, and it takes precedence over a person's will. The table on the slide applies to the rules as they are in France, to give you an idea of what forced heirship rules look like in practice. In this scenario, the deceased is married, with children, and has also made a will. If the deceased has one child, he must leave that child at least half of his assets on his death. He can leave the other half of his assets under his will. If he has two children, he must leave them 2/3 of his assets and leave the remaining 1/3 under his will. If he has 3 children or more, he must leave them 3/4 of his assets and can leave the remaining 1/4 under his will. Each child must receive their share equally, so there is no opportunity for favoritism. You will see that forced heirship rules protect children from being disinherited, but as a consequence, the widow or widower often doesn't receive much, which can cause worry and concern. Forced heirship where no will exists. If the deceased is married with children but has not made a will, his surviving spouse can inherit either 1/4 of his assets or a life interest in his whole estate. If the deceased was married but without any children, the surviving spouse is entitled to half of the deceased's assets or a life interest in his whole estate. I need to mention matrimonial property regimes at this point, as they can impact the succession of your assets. We do not have matrimonial property regimes in this country, but our comparison would be a prenuptial agreement, although there are differences between the two. When you marry in Europe, as a couple, you enter into a property regime, which decides how you want to split your assets on divorce or death. Different regimes have different rules about what kind of property and how much of it is included in the regime. Importantly, your spouse's entitlement is worked out under the regime before your assets pass under your will. So let's have a look at this in practice. Mr. X dies, leaving an estate worth £1 million. He's survived by his spouse and 3 children and has made a will. In England, most people would choose to leave everything to their spouse on the first death, and then everything to the children on the second death. However, in France, even with Mr. X's will, the system of forced heirship produces a different result. The 3 children inherit 3/4 of Mr. X's estate. Mr. X can choose only what happens to the remaining 1/4 share under his will. He could leave this to Mrs. X. This might mean that Mrs. X may not have enough resources to look after herself and her family. But there are a few things Mr. X can do in France during his lifetime to mitigate the situation, for example, purchasing a life insurance policy. Brussels 4, also known as the European Succession Regulation. This is an EU regulation which came into force in August 2015. It is therefore still relatively new law, and you may wish to think about updating your wills to take advantage of it. In 2015, Denmark, Ireland, and the UK did not sign up to the regulation, but it still remains relevant in cross-border succession matters. It can be particularly useful for British nationals who want English law to apply to the succession of their assets. This is because the regulation can help them bypass local forced heirship rules. But remember, the regulation only applies to matters of succession. It doesn't allow you to choose which country's inheritance tax regime is applicable to your assets. Testators should also be aware of potentially adverse tax consequences of making an election under Brussels 4. For example, if you decide to leave your assets to whoever you like, that could mean your estate might pay a higher amount of inheritance tax. And if you elect for English law to apply to the succession of your estate, and you leave your estate to whoever you like, this could give rise to a 1975 Act claim or a claim under proprietary estoppel, which I mentioned earlier. Trudy is a British national who is living in France. She is estranged from her daughters and does not wish to include them in her will. Instead, she would like to leave her entire estate to a UK charity. Trudy is habitually resident in France, therefore French law automatically applies to the devolution of her estate. Under the system of French forced heirship, Trudy would have to leave 3/4 of her estate to her daughters, being 750,000, and she is only free to leave the remaining 1/4, 250,000, to the UK charity. However, because Trudy is a British national, she can make an election in her will for English law to apply to the succession of her estate. Trudy can therefore bypass French forced heirship rules and leave her entire estate to the UK charity. Brexit will not affect the application of Brussels 4. The UK was one of the countries who did not sign up to the regulation back in 2015. This means that the UK is already treated as being a state outside of the EU for the purposes of Brussels 4. So from the 1st of January 2021, a UK national will still be able to elect for the succession laws of the UK to apply to their estate, in the same way that they could before Brexit. Now let's move on to the topic of inheritance tax and see how Brexit could change this. This is a simple overview for those without a legal background on how inheritance tax works in different jurisdictions. This table compares the UK and France. We have used France as an example, but many European countries' inheritance tax regimes look very similar in that the beneficiary bears the tax burden. In the UK, inheritance tax is payable by the estate. When you die, your executors will add up all of your assets, deduct any liabilities you had at the time of your death, and the amount left over we call your estate. The estate has a tax-free allowance, and generally speaking, anything over the tax-free allowance is taxed at a flat rate, regardless of who the beneficiary is. Although there are some exceptions to this, for example, your spouse and charities. But broadly speaking, regardless of who you leave your assets to, being your children, friends, nephews, nieces, the tax rate is going to be the same. By contrast, in other European jurisdictions, rather than the estate paying the tax is payable by the individual beneficiary. The tax-free allowances and the rate of tax payable is determined by the level of kinship that the beneficiary had with the deceased. Generally, for tax purposes, the closer the better when it comes to the amount of tax which is paid. In France, for example, a child of the deceased can receive €100,000 from each parent tax-free. But an unrelated beneficiary, for example, a friend or a stepchild, can only receive €1,594 tax-free. There are some exemptions in France. For example, spouses don't have to pay inheritance tax. The rate of tax is not a flat rate like it is in the UK, as it depends on who is inheriting. For example, children pay a relatively low rate of between 5 and 45%, depending on how much they inherit. But unrelated beneficiaries get charged a whopping 60% rate of tax. Let's look at how this works in practice and go back to the example of Mr. and Mrs. X. So following Mr. X's death, Mrs. X now dies, leaving an estate made up of her home and some savings worth £1 million to her 3 stepchildren. So if Mrs. X and her assets were in the UK, we would work out the tax-free allowances available to her estate at the time of her death. This is not to say that everyone has a £1 million tax-free allowance available to them. This would be carefully assessed at the time of Mrs. X's death. In this scenario, her taxable estate is zero, and each stepchild therefore inherits roughly £333,000. By contrast, in this particular example, if Mrs. X and the assets were in France, her estate works out at roughly €1.125 million. Each child would receive €375,000, but they would then be taxed on that amount, and because they are a stepchild of the deceased, they only have a very small tax-free allowance of €1,594. They get taxed at a flat rate of 60%. This means each child would inherit approximately €149,362, which is a very different result as compared with the UK. But of course, in some situations, it is better to be taxed under the French system. For example, if you have lots of children, there will be a lot of tax-free allowances available. And if they are biological or legal children rather than stepchildren, then the tax-free allowances are much more generous. So which country gets to charge inheritance tax in a cross-border situation? I should mention here that this could be a webinar topic all by itself, So this is a very quick overview of the rules. Firstly, it's important to note that some countries charge no inheritance tax at all, and some countries charge tax in a very different way. For example, in Australia, there is no inheritance tax, but there can be income and capital gains tax implications on death. Looking at Europe, Portugal does not have inheritance tax, but it does have stamp duty payable on death. For the countries which do levy inheritance tax, they can charge inheritance tax based on the deceased's residence or domicile, or even on the basis of their nationality. In some jurisdictions, your domicile can be as simple as where you live, but that is not the case in the UK. For example, under the UK definition of domicile of choice, the intention element is not based on what you say or even what you think. It is measured by what you do. In the UK, we look to a person's domicile to ascertain their inheritance tax status. If a person is domiciled within the UK, HMRC will want to tax their worldwide estate on death. They will want to tax all assets, regardless of which country they are located in. Generally speaking, if an asset, especially real estate, is located within a particular country, the local tax regime would generally want to assess that asset for tax, regardless of the location of the owner. When working with cross-border estates as much as we do, it is very common for us to come across situations where two jurisdictions want to tax the same asset. So, for example, for a UK domiciled person owning a property in France, HMRC is going to want to tax that property because it falls within the person's worldwide estate. And the French revenue will also want to tax it because it's located within France. This brings me on to our next slide, double taxation treaties. These treaties can be very useful in a cross-border context. The UK has double taxation treaties with a number of other countries for inheritance and succession tax matters. These treaties regulate which jurisdiction has the authority to tax which assets and how the state can recover any tax that is paid twice. The UK has double taxation treaties with 5 EU member states. These are France, Ireland, Italy, the Netherlands, and Sweden. But where there is no double taxation agreement in place, this isn't necessarily a disaster, as unilateral relief from HMRC may be available under Section 159 of the Inheritance Tax Act 1984. So, is Brexit going to change these double taxation agreements? Broadly speaking, no. The double taxation treaties are not EU law, and so they will not be automatically revoked on the 1st of January 2021. So will Brexit affect tax liability in Europe? When I say tax liabilities here, I'm not talking about all types of taxes, but specifically inheritance and succession taxes. Most countries do not distinguish between EU and non-EU nationals for rates of inheritance and succession tax. But that isn't the case for all types of taxes. For example, Spain levies a higher rate of capital gains tax on non-EU nationals as compared with EU nationals. EU member states are prevented from doing this to other citizens of EU member states. But from the 1st of January 2021, UK nationals who own assets in Europe will no longer be treated as being EU nationals. This could change the amount and/or rate of certain other taxes they are required to pay locally. So, in summary, you can see that the rules governing succession in Europe are not going to drastically change on the 1st of January 2021. Brussels IV will remain unchanged, and there won't be any change to how double taxation treaties work. But there may be other types of taxes to consider. For example, the capital gains tax issue in Spain for non-EU nationals who own assets in EU countries after the 31st of December of this year. I should also mention at this point that UK charities will not enjoy the same inheritance tax exemptions in Europe post-Brexit. If anyone wants any further information on this point, Dan can answer your questions in our questions section. Thank you for listening to this brief webinar, European Succession and Brexit, a guide for beginners. I hope you found it a useful introduction to the issues of succession and inheritance taxation in Europe. If you encounter any difficulties with your planning or need any help, please do not hesitate to contact us and we would be happy to help you. I believe there have been some questions coming in over the course of the webinar, so it's time to hand over to my colleague Dan to answer those.
Thanks, Emma. Good morning, everyone. My name, as Emma says, is Dan Harris. I'm the head of the international and cross-border team at Stone King. We've got a few questions that have come in. I'll start off with the straightforward ones first. Are all forced heirship regimes the same? And the answer to that is no. Forced heirship is essentially a civil law concept. It's something that was passed down effectively from the Romans, but each jurisdiction has tweaked them slightly to suit their own needs, really. In France, as Emma said, if you have one child, the child's entitled to 50% of your assets. If you have two children, they're entitled to 2/3 of your assets. If you have 3 children or more, they're entitled to 3/4 of your assets. In Spain, for example, your children are entitled to 2/3 of your assets, and again, this is regardless of what it says in your will. They're entitled to 2/3 of your assets. 1/3 of those 2/3 has to go to your children equally, and the other third of those 2/3 can be left unequally between your children, but it still has to go to your children. The remaining third you can leave by will to whomever you wish. The other thing that's probably worth mentioning is that, as an aside, with forced heirship regimes, our attitude in the UK and in many common law jurisdictions is that that doesn't seem fair, really. If you've accumulated funds during your lifetime, why shouldn't you be able to leave them to whomever you wish? The cultural difference is really quite strong in different jurisdictions, and they think the opposite. They look at us in the UK and they think, well, you know, you're immoral, surely, not leaving your assets to your children. And to an extent, they've got a point. The other thing the forced heirship systems do is in the UK, there's quite a lot of litigation that surrounds wills and estates after a person's passed away. And forced heirship systems do tend to remove that litigation. Everyone knows where they are from the outset. And the other cultural difference, I think, is that it's assumed in civil law jurisdictions that at least part of the wealth that you receive has been passed down by your family, and so you have an obligation to pass it on to your family as well. So it's a different way of thinking, not necessarily better, not necessarily worse, just different. I have another question here. Which countries do you cover? So at Stone King, technically, because of the way we train our teams, we train them to understand the building blocks, the principles of private international law. And because they understand those principles of private international law, they can apply them to pretty much every jurisdiction. Now, we would struggle, I think, to do a jurisdiction like North Korea, but pretty much every other jurisdiction, and certainly every European jurisdiction, we are very comfortable with doing. And that brings me neatly onto another question that we received. How do I get a foreign will made? And so when it comes to the EU, there's scope within the European succession regulation for a UK lawyer, for example, to draft your European will. And you might think, well, hang on a second, how can a UK lawyer possibly be any good at drafting a foreign will? What would they know about foreign law? And here's the thing. So within the European succession regulation, Article 22 tells us that it's possible to make an election, which is a choice of law, for you to choose the laws of your nationality to apply to the devolution of your estate. So if, for example, you have assets in Germany or Italy or France or the Netherlands or Spain, wherever it happens to be, and you're electing for English law to apply to the succession of your estate, who's better positioned to draft that will? Is it an Italian lawyer or a Spanish lawyer or a Dutch lawyer who knows absolutely nothing about English succession law, or is it an English succession lawyer? Is it valid? Yes, it's valid. Article 27 of the European Succession Regulation tells us that that an English will drafted for a British national is as valid as a local will in any of the other jurisdictions. But you need to take care when getting those wills drafted, because it's very, very easy to get the cross-border issues wrong. Another question that I've got here, sorry, I'm just reading through them. Can you tell me more about the charity tax issue? So this is quite a significant change that will happen as a result of Brexit. So in the UK, if you leave some of your assets to charity, then there's no tax charged on that particular element of the gift. Also, if you leave a certain amount of your assets to charity, so if you leave 10% of your estate to charity in the UK, there's a lower tax rate that applies to the rest of the estate. So the rest of the estate is only subject to 36% rather than 40%. But this is not the same in other jurisdictions. In other jurisdictions, UK charities are generally charged tax. So if your estate, if you're, for example, giving away assets in Germany to a UK charity, then the default position is that the taxing authority, the local taxing authority, is allowed to look at that issue and tax the estate. Now, with Brexit, sorry, prior to Brexit at the moment, there's a case called Heim, Perscher and Finanzamt Leutenscheid, which is a European Court of Justice case. And that European Court of Justice case effectively says that where a local tax authority, certainly in the case I just mentioned, being Germany, where the German tax authority would allow tax concessions to their own charities, they must allow tax concessions to British charities as long as that British charity would qualify as a charity in Germany. And we've applied this rule many times over the years. We've applied it in France, we've applied it in Germany, and we've applied it in Italy. And we've been very successful in ensuring that UK charities or the gifts that are made from your estate are not taxed. And one of the issues is that often the gifts to charities, because they are unrelated beneficiaries, there's no kinship link, they're charged at the highest tax rate as well. So it adds insult to injury. With Brexit, it seems that there is a probability, and I'm not going to say it's absolutely certain, but there's a probability that we won't be able to apply that Heim, Perscher and Finanzamt Leutenscheid case again going forwards. And that's going to be a very big disappointment. But we will still continue to look and see what options there are for mitigating tax in the local jurisdiction. And some of the possibilities may be that we can actually have the charity registered as a charity in the local jurisdiction. But that's something we're looking into at the moment. So that brings me to the end of the questions I've received. I can't see any other questions on the board. And so, excuse me, and so I'm going to pass back to Emma briefly, just to wish you a good day. Emma?
Thanks, Dan. Brilliant. I think that brings us to the end. I believe